Today I received a response from the Office of the Comptroller of the Currency, which has been added to the record, MRE 140, which reads as follows. Date October 31st, 2025. Action letter from the Office of the Comptroller of the Currency, OCC. Description: fraudulent notice of case number CS04045555. The Office of the Comptroller of Currency, OCC, issued a fraudulent notice under the supposed case number CS04045555, falsely asserting that the agency holds no liability or jurisdiction regarding negotiable instruments or related commercial enforcement and responsibilities. Hopefully you caught the fraudulent part of all this. Because, factually, despite lawful notice of federal jurisdiction, commercial injury, and manipulation violation of constitutional and statutory law, the Office of the Comptroller of Currency, OCC, engages in deliberate obstruction, and procedural deflection. The agency's Customer Assistant Group, CAG, expressly tasked with enforcing consumer protection and regulatory compliance, issued correspondence on October 31st, 2025, falsely asserting that the matter is outside of our jurisdiction. This statement is factually and legally false and constitutes administrative misconduct under 12 United States Code 481 and 1820D. The OCC holds explicit supervisory authority to investigate and enforce compliance within the applicable banking statutes, consumer protection laws, and negotiable instrument regulations. Their written dismissal contradicts not only the mandates but also United States Code, 18 United States Code 4, misprision of felony, 18 United States Code 241 and 242, conspiracy and deprivation of rights under the color of law, and their fiduciary duties under Title 12 and 31 of the United States Code. Notably, the OCC assigned case number CS040455 only after being named as a defendant in a federal complaint. Same shit I've been dealing with. Okay. This belated issuance of case number constitutes reactive fabrication and creates a false appearance of procedural compliance. Such post hoc acknowledgement does not erase liability. It proves ongoing violations, delays, and deliberate obstruction already on the record. This correspondence, viewed in the broader and context of federal evidentiary record, substantiates the very misconduct previously alleged: systemic delay, suppression of remedy, unlawful obstruction, and concealment of criminal activity by the agency charged with regulatory enforcement. The behavior constitutes fraudulent misrepresentation, the resolution of duty, and complicity in continued harm through omission. The OCC's conduct mirrors the same pattern of administrative avoidance exhibited by the FTC, CFPB, and DOJ, each in each invocably fabricated jurisdictional limitations, innovate enforcement, and clear statutory violations. This consistent pattern reflects the collision and systemic administrative corruption herein agencies knowingly refuse and uphold the law, obstruct remedy, and protect the institutional liability and expense of constitutional rights. By its own governance statutes, the OCC was legally obligated to investigate and enforce protections concerning the negotiable instruments and commercial transaction at issue. This continued refusal to act constitutes malfeasance, gross negligence, and further violations under 18 United States Codes 241, 242, 1503, and 1512. Let me repeat that. By its own governance statutes of the OCC was legally obligated to investigate and enforce protections concerning the negotiable instruments and commercial transaction at issue. Its continued refusal to act constitute malfeasance, gross negligence, and further violations under 18 United States Code 241, 242, 1503, and 1512. Conclusion. The October 31st, 2025 OCC correspondence is hereby entered into the master record of evidence as proof of continued fraud, concealment, and administrative misconduct at the federal level. It confirms the multiple federal agencies, upon lawful notice and escalations, have chosen to shield institutional wrongdoing rather than uphold the constitutional and statutory duties. This response and the pattern it exemplifies constitutes substantive evidence of federal complicity and systemic violation, reinforcing the necessity for the Supreme Court's intervention, federal oversight, and immediate constitutional remedy. In other words, everything that I just shared with you solidifies everything that I've already reported and proven on the record. Again, the criminals is still committing criminal activity. And everything that I'm reporting solidifies everything that I've already reported, including the continuance of harm, violations, and crimes being committed by the very system that I am reported everything to, who holds not only oaths, but lawful responsibilities to uphold law and human rights, whether constitutional or declarational. Show up, because I am. Reporting the same violation, crimes, and harm committed by the very systems that is obligated to uphold the same violation, crimes, and harmful acts that I am already reporting. In other words, just because you are doing these harmful acts as public servants does not mean that you will not be held accountable. Period. And y'all are. So let's get it together. SAP.